Welcome to Litigation Help. My name is Heather Littman. The next few weeks, we're going to get into the topic of wills and estate planning. My guest speaker today is lawyer Samuel Michaels from SM Legal. Sam practices in business law and employment law and estate planning. Sam is a regular contributor here at Litigation Help. Welcome, Sam.
Thanks, Heather. Yeah, very excited to get started on this series and talk about some estate planning, some basics and some complex stuff as well, I'm sure.
I'm sure. So first question, so what happens if you die without a will?
Okay, so I think that's a great question to start with. If you die without a will, there's this conception that goes around that I've heard as well, that all your money is going to go to the government, right? That they're going to take everything. And that's not exactly the case. If you pass away without a will, it's called dying intestate, which is basically the legal term. And if you pass away intestate, there's an act, a legal statute called the Succession Law Reform Act. And that statute basically goes through a list of people who can inherit the estate.
So, Sam, what are the formal requirements for a will in Ontario?
Yeah, so there's a couple different ways that you can do this, actually. You can, in Ontario, just handwrite a will. That can be on a napkin, on a piece of paper. You can have it completely handwritten and only signed by you, and that's called a holographic will. And that's actually a valid type of will. The other option that you can have is a typed up will, but if you're typing up your will, it needs to be signed by the testator, by the person who's giving the instructions, whose will it is. And it needs to be signed by two independent witnesses. So that means they have to be witnesses who are over the age of 18, age of majority, and witnesses that are not beneficiaries under the will. So it is possible to have your executor as a beneficiary, but you can't have your witness as a beneficiary. Those need to be different people. And when you're signing, not to get too many requirements, but there's a bunch of them, when you're signing, the testator and the witness need to be in each other's presence and signing at the same time. It needs to be one meeting where everyone gets together and signs the will. Testator signs, first witness signs, second witness signs. With COVID in the years from, I guess, mid-2020 through at least now, and we're in September 2021 as we're filming, you can do remote signings. The reason I'm giving the dates is because we're not sure how long that's going to last, right? It might stay. It does seem like there's a lot of push within the legal industry to keep those remote signing options. But hard to know, right? The rules are changing. And another rule that's also changing is around that split between the handwritten will and the typed up will. So it seems like there may be some changes in the future where there's a little more flexibility to type up a will and have it just signed by one person. But for now, if you're typing up your will, make sure it's the testator signing and two independent witnesses.
Okay, so now why is it important to have a valid will?
Yeah, so the main reason would be if the will is put through the probate process. So if, for example, a bank says before releasing the funds, we need to see a probated will, a will that's been approved by the courts. If you take that will in and the will doesn't fulfill the formal requirements, it may not pass through the probate process, or it might not get probated, and then be a much longer process to get the funds released from that bank account. So it's not always strictly essential, right? If the estate's being managed privately and doesn't need to go through probate, I could see a possibility where it could be that you can sort of get away with just having a not formally valid document and just using that as sort of a guide for the family. But generally, to be on the safe side, it's better to follow the correct formalities.
That's great, Sam. So can you tell us what is the relevant legislation, just in case people want to read up and find out more information?
Yeah, absolutely. It's the Succession Law Reform Act, the SLRA, and succession is basically just another word for the passing on of an inheritance. So that's the source for all this, and it also goes through all the intestate rules, which are the rules for if you pass away without a will at all, right? You have nothing documented. There are actually rules in the SLRA that go through who's going to get the estate and the assets in the absence of a will.
These laws are really just specific to Ontario. Is that correct?
That's correct. Yeah. So there's a similar legal regime for each province, and I'm not positive, but I think it would be virtually identical province to province in terms of the ways that they look for these lineal and non-lineal descendants to pass the estate on to. But definitely worth keeping in mind. It's different per province, and it's also different internationally, of course.
Oh, wow.
Right? If you pass away in a different country, or you're a citizen of a different country and pass away there and have some beneficiaries in Canada, the legal treatment will not be the same.
And so I guess the affidavit execution has to be sworn by the witnesses. It should be sworn by the witnesses. Is that correct?
Yeah.
Okay. You know what? I never knew that you have to do that. Never learned that in law school, which is kind of weird.
Yeah, again, you don't have to, right? It's
Okay.
not required to make the will legal. Really, it only comes up in one circumstance, which is a will challenge about the signatures.
Okay.
Right. So if there's a will challenge regarding, that this is a forged signature, right? The testator didn't sign, it's a fake.
Right.
Then you could bring the affidavits forward as evidence saying, well, like, here's a piece of evidence from this witness saying I was in the presence of this individual signing, so it's not forged because this person is also swearing to the truth of that the person was there. So it matters in that one context.
Okay.
Pretty much doesn't matter for any other situation, right? Because even if there's a capacity challenge, having the affidavit doesn't really show anything. You can just the lawyer can just be like, well, the witness, they can't assess capacity, right? They don't know or whatever. So it's funny, like every lawyer does them with a will. It probably comes up one in every million estate situations. It comes up very rarely, but
I see. Okay, right. Interesting.
I think people just figure it's like an extra minute to put it together and can save a lot of trouble down the road. So
makes sense. Sounds good.